Good evening, everyone. Connect here. I'm much delightful to offer a hearty welcome to all the people connect here to the virtual orientation program on intellectual property rights in association with the National Intellectual Property Awareness Mission. This orientation program is organized by Research Committee of GVN College. It's indeed a proud moment to all of us. A word of hearty welcome is the sweetest of all things in life. A smile that radiates love to all the people around makes everyone happy. I request Dr. P. Santaraman sir, Assistant Professor of Chemistry and Convener of Research Committee of our college, to formally welcome the gathering.
Good afternoon, everyone. It's my immense pleasure to welcome you all to this wonderful program organized by our college research committee. First of all, I express my hearty welcome to our respected secretary sir, principal ma'am, and director sir. I extend my hearty welcome to today's resource person, Mr. M. Madan Raj, examiner of patent, Indian Patent Office, Government of India, Chennai. And finally, I welcome our faculty members and PG students of our college. I request all of you to make use of this session. Thank you.
Thank you, sir, for your earnest welcome address. Now, I would like to invite Dr. P. Magendran sir, Secretary of our college, for the presidential address. Please, sir.
Joyce ma'am, it's okay ma'am. Next you can call our principal ma'am.
Thank you, sir. Next, I would like to invite Dr. N.R. Santimaheshwari ma'am, principal of our college, for the felicitation address.
ஜாய்ஸ் மலர் நான் பேசுறது கேக்குதா?
Audible, ma'am.
Okay. Respected secretary, respected director of and honorable resource person, Mr. P. Madan Raj, examiner patent and design, Indian Patent Office, Government of India, Chennai, and convener Dr. P. Sandaraman, Department of Chemistry, and coordinator Dr. G. Selathurai, Department of Zoology, and organizing committee members and dear participants. Very good evening to all. First of all, I congratulate the organizers of this webinar, virtual orientation program on intellectual property rights in association with the National Intellectual Property Awareness Mission. The establishment of research and development cell in colleges is a part of NEP 2020 implementation, and hence we require immediate attention and action. Intellectual property is protected in law by, for example, patent, copyright, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. Intellectual property system aims to foster an environment in which creativity and innovation can flourish. So every faculty should attend specialized courses on intellectual property to improve your skill, whatever your level knowledge or interest. Attending this orientation program will create awareness to every faculty members. Enjoy this session. Thank you.
Thank you, ma'am, for your lovely words. Next, I would like to invite Dr. G. Chaladurai sir, Assistant Professor of Zoology, to address the chief guest.
Good evening to everyone. The respected Principal Sir, Secretary Madam, and Chief Guest, Army Secretary and participants. I am proudly privileged to take this opportunity to introduce our Chief Guest of the session. He is none other than Mr. M. Madandra Sir. He is the National Intellectual Property Awareness Mission Trainer. He pursued M.Tech Biomedical Engineering at SRM University, Chennai. He has 6 years of rich experience in academic and government services. He was trained at the Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. He is currently working as an examiner of patent and designs in Indian Patent Office, Chennai. He has acted as a resource person in various IPR awareness program across the southern state of India. Besides, he is also known as the official trainer of NIPAM, the Government of India. This is a big round of applause for Mr. Madandra Sir. Without a further delay, I invite Mr. Madandra Sir to deliver the chief guest address.
Thank you, sir, for a wonderful introduction of our chief guest. The role of a good leader is not to give greatness to human beings, but to help them extract the greatness they already have this inside them. I invite our chief guest, Mr. M. Madanraj sir, Examiner of Patents and Design, Indian Patents Officer, Chennai, for the keynote address. Please, sir.
Thanks a lot for the warm introduction. So, good evening, everyone. Am I audible?
Yes, sir, audible.
Okay, fine.
Sir, it is audible.
Okay, thank you. So, as we all know, this awareness program is all about intellectual property rights. So, first of all, I would like to thank the college, the principal, the faculties, and the management for organizing this webinar to enhance their knowledge in intellectual property rights. So, this particular IPR awareness program is an initiative by the Government of India under the banner NIPAM. So, NIPAM is nothing but National Intellectual Property Awareness Mission. So, we started NIPAM in the last year so that we could cover a larger number of audience to enhance their knowledge in intellectual property rights. Since we got a huge success and wide reach for the phase 1 of NIPAM, so Government of India again tried to extend it for the phase 2 of NIPAM so that even more larger audience is getting covered by this awareness program. So without further delay, we'll start with the presentation. So in the upcoming slides, we'll be dealing about the different types of intellectual property. What are the definitions of each and every intellectual property? What are the works which can be protected under each and every intellectual property, and how to file for your intellectual property? So all these topics in brief, we'll try to cover in this 1 hour webinar of in the upcoming slides. So is my presentation visible to everyone? My slides are visible?
Yes, sir. It is visible, sir.
Okay, fine. Thank you then. So this is just a disclaimer and copyright slide saying that this presentation is purely for educational and awareness purposes only. So it is not supposed to be recorded or reproduced without the office of permission from the office of CGPD team. So let me start with a very interesting example. I know many of you are active users of social media. So social media எல்லாருமே யூஸ் பண்ணிட்டு இருப்பீங்க. Facebook, Instagram, Messenger, WhatsApp, day-to-day life we are using it every day. So few years back, Facebook has changed its name to Meta. I hope that everyone is aware of that particular fact. How many of you are aware of the fact that actually Meta it was bought, the name was bought by Facebook from some other company? How many of you are aware of that fact that the name Meta, it was already registered under a company called South Dakota Bank? So South Dakota Bank கீழ Meta Financial Company என்ற ஒரு நேம் ரெஜிஸ்டர் பண்ணி வச்சிருந்தாங்க. So Facebook owner Mark Zuckerberg, he has to pay a whooping amount of $60 million. So on the Meta name oda rights வாங்குறதுக்கு he paid $60 million to get the name rights for Meta. So imagine the power of protecting your intellectual work and how much financial gain you might get by protecting your intellectual work. So this is a very interesting example to portray why is it important to protect your intellectual work and how much of a financial gain also you can obtain by protecting your intellectual work. So the next question which will pop up in your mind is, what is intellectual work and what is intellectual property? So property in Eduthuta, there are two different types of property. One is tangible property and the other property is intangible property. So what are tangible properties? Tangible properties are things which are visible to your naked eyes, which you can feel it, which you can touch it. So all those properties are tangible properties. What are examples for tangible properties are a car or a bike or a building or a house. All those are tangible properties because உங்க கண்ணால பார்க்க முடியும், நீங்க feel பண்ண முடியும், touch பண்ண முடியும். Those are physical objects. So what are intangible properties then? Intangible properties are things which are not visible to your naked eyes, which you cannot feel it or which you cannot touch it. So intellectual property is a part of intangible property. What is intellectual property then? Intellectual properties are things which are created from your own mind. உங்க மைண்ட்ல இருந்து ஒன்னு எக்ஸ்பிரஸ் பண்ணி நீங்க ஒரு ஐடியா இல்ல ஒரு புக் எழுதுறீங்க இல்ல ஒரு பெயிண்டிங் எழுதுறீங்க, all those ideas are generated from your own mind. Your mind creates those ideas. So the properties which are being extracted or created from your own mind, all those properties are called intellectual properties. So the examples for intellectual properties are inventions, books, paintings, or it can be a new song or the song lyrics, or a business model, or mathematical expression, or computer algorithm. So all these properties are created from your own mind. It is an expression of an idea from your own mind. So these properties will come under intellectual property. So in the last line I mentioned, intellectual properties are territorial in nature. So what do you mean by territorial in nature? So if you take a country, it has a boundary to it. So ஒரு boundary இருந்ததுன்னா, if that particular boundary, we call it as a territory. That whole country, we call it as a territory. The boundary on the territory. So for example, if you are applying for a patent protection in the country of India, your patent protection will be, the protection is valid only where you have applied for that patent protection. எந்த கண்ட்ரியில் அப்ளை பண்ணுறீங்களோ அந்த கண்ட்ரியில் மட்டும்தான் அந்த பேட்டன்ட் வந்து ப்ரொடெக்ஷன் வந்து அந்த வேலிடாக இருக்கும். ஸோ சப்போஸ் இஃப் யூ வாண்ட் யுவர் பேட்டன்ட் டு பி ப்ரொடெக்டட் இன் ஜெர்மனி ஆர் இல்லைனா யுனைடெட் ஸ்டேட்ஸில் வந்து ப்ரொடெக்ட் பண்ணணும்னா யூ நீட் டு அப்ளை ஃபார் அ patent protection, patent application in that particular country, in German patent office or United States patent office, to get your protection valid over there. So this is not only applicable for patent, be it any intellectual property. So it is all territorial in nature. எந்த கண்ட்ரியில் நீங்கள் வந்து அப்ளிகேஷன் போடுறீங்களோ அந்த கண்ட்ரியில் மட்டும்தான் உங்களுக்கு ப்ரொடெக்ஷன் வேலிடாக இருக்கும். ஸோ தட் இஸ் வாட் இஸ் மீன் பை intellectual properties are territorial in nature. So the next question which will come to your mind is, what is the importance and significance of protecting your intellectual property? எதுக்காக நான் வந்து ரெஜிஸ்டர் பண்ணணும்? What is so important that I need to protect my invention or books? So suppose if you are buying, let's take an example of a tangible property. So suppose if you are buying a house or if you are buying a car, what is the next step you do? காரோ இல்லை ஒரு வீடோ வாங்கிட்ட பிறகு அதுக்கு அடுத்த ஸ்டெப் என்ன பண்ணுவீங்க? எஸ், எனிஒன்? You can type your answers in the chat section or you can unmute the mic and let me know. So once you buy a house இல்லை ஒரு கார் இல்லை ஒரு வீடு வாங்குனீங்கன்னா, you go and register it with the, suppose if you're buying a house, you go and register it with the sub registrar office, or ஒரு கார் வாங்குனீங்கன்னா அதை ஆர்டிஓவில் போய் ரெஜிஸ்டர் பண்ணுவீங்க. So why do you register it? You register it so that you have a proof that you are the sole owner of that particular property. So register பண்ணாதான் அந்த காருக்கு நீங்க ஓனர், அதில் லேண்டுக்கு நீங்க ஓனர், இந்த ஹவுஸுக்கு நீங்க ஓனருக்கு you have a valid document with you that you are the sole owner of that particular property. So same principle applies for intellectual property also. So you're putting a vast amount of time, effort, and hard work and money to create something which is unique, which comes out of your own mind. It is your own thinking which is creating a product. It can be a novel, or it can be a new device to solve a problem. So it can be a painting, எதுவா வேணா இருக்கலாம். It can be a photograph. So அது எல்லாமே, it is all your own creativity. So it is very much important that you register and protect it so that you can stop others from using your work. மற்றவங்க யாரும் உங்க பெர்மிஷன் இல்லாம உங்களோட ஓன் கிரியேட்டிவிட்டியை வந்து எக்ஸ்ப்ளாய்ட்டோ இல்லை யூட்டிலைஸோ பண்ணிடக்கூடாதுன்ற ஒரு மெயின் ரீசனுக்காக யூ ஆர் ப்ரொடெக்டிங் யுவர் இன்டெலெக்சுவல் ஒர்க் and you are registering it so that you will have a proof that you are the owner of that particular intellectual work also. So once you protect panni, you are excluding others from using your invention, then you can utilize those particular intellectual work for commercially earning from those intellectual work also. So how do you earn? Suppose if you're writing a new novel, you can approach a publisher, and the publisher novel publish panni, you can get a percentage of profit from the selling margin. And if you're inventing a new device, you can start manufacturing of the new device, and then you can sell it in the market, or you can even start your own company or startup on start panni, you can start gaining or earning from those particular devices. So there are multiple ways to earn from those particular intellectual properties also. So it is very much important that you register and protect your intellectual work. So these are the different types of intellectual property which we are going to deal in the upcoming slides. Sila names you might be familiar with. So the types of intellectual property which we are going to deal are patent, design, trademark, copyright, geographical indication, semiconductor integrated circuits, layout and design. So the first intellectual property which we are going to deal with is patent. So what is a patent? A patent is an exclusive right granted in respect to an invention. So a patent is a right, it is a right which is given to the inventor. It is given to the invention. ஒரு இன்வென்டருக்கு ஒரு எக்ஸ்க்ளூசிவான ரைட் கொடுக்குறோம் ஃபார் தட் பர்டிகுலர் இன்வென்ஷன் விச் ஹீ கிரியேட்டட். ஸோ பேட்டன்ட் இஸ் எக்ஸ்க்ளூசிவ் ரைட் கிராண்டட் வித் ரெஸ்பெக்ட் டு அன் இன்வென்ஷன் விச் மே பி அ ப்ராடக்ட் ஆர் அ ப்ராசஸ். அந்த இன்வென்ஷன் இட் கேன் பி அ டிவைஸ் ஆர் அ ப்ராசஸ் ஆஃப் டூயிங் சம்திங், இல்லை ஒரு மெத்தட் ஆஃப் டூயிங் சம்திங்காக இருக்கலாம். ஸோ தட் இஸ் வாட் இஸ் மீன் பை இட் கேன் பி அ ப்ராடக்ட் ஆர் அ ப்ராசஸ் that provides a new and inventive way of doing something. ஒரு விஷயத்தை புதுவிதமா பண்ற மாதிரி இருக்கணும், or else it should offer a technical solution to a problem. So a problem existing இருந்ததுன்னா, if you're finding a technical solution for that particular problem, then a patent can be granted towards your particular invention. So this is the basic definition of a patent. So patent it has a very limited period of protection only. So it has a limited period of 20 years. So suppose if you're applying for a patent application in this month of November 2022, your patent will expire in the year of November 2042. So 20 years is the validity for a patent protection. So what will patent provide you? It will give you the right to exclude others from using your invention. So you can stop any stranger or a third party from copying your invention or replicating your invention. You can avoid them by getting your invention protected under patent. So these are the different examples of a patented product. So inga pathina, the first picture is a head cover for a baby. The second picture is a foldable hanger, and the third picture is a cardiac pacemaker, and the fourth picture is a internal combustion engine. So there is it is not always necessary that only complex inventions will be patentable. So even simple inventions which are offering a technical solution can also be patentable. So the head cover for a baby is a very simple invention, and foldable hanger is also a very simple invention, but it is offering a technical solution. On the foldable hanger, என்ன technical solution offer பண்ணுதுன்னா, it is if there isn't enough space in your wardrobe, நிறைய ஸ்டோரேஜ்க்கு இடம் இல்லைன்னா for hanging your hangers in the wardrobe, then you can fold your hangers and keep it inside the wardrobe itself. So on the space constraint என்ற problem வந்து it is offering a technical solution to solve the problem of space constraint. So not only complex inventions, even simple inventions can be patentable. So to approach a problem, how to approach a problem, அதை explain பண்றதுக்கு I've taken these two inventions. So if you take the invention on the left side, so left sideல என்னன்னா, a small kid is brushing in front of a display system. So இந்த invention எதை பத்தி பேசுதுன்னா, it is a visual guidance system to teach kids how to brush their teeth. So you can see a small kid is standing in front of a display system, and the small kid, it is holding a dynamic toothbrush. So dynamic audio is there, and the trans receiver is there, a display system, a multimedia controller. So அந்த brush வந்து எந்த directionல அந்த kid move பண்ணுதோ, the same direction will be displayed on the TV, and we can clearly tell the kid to visualize it through the display system. அதை பார்த்துட்டு brush பண்ண கத்துக்கிறதுக்கு சொல்லி தரலாம். So this is one way of approaching a problem. So if you come on to the right side, there is another invention that is also a normal brush. So அந்த normal brushல என்ன பண்ணிருக்காங்கன்னா, they made a tiny modification in the particular brush. And the tiny modification என்னன்னா, they've kept ball bearings in between the brush. So usually doctors வந்து advise பண்ற brush movement வந்து it is up and down motion. So if you move this particular brush in up and down motion, the ball bearings will also move up and down, and then it will start making sounds. But if you move this particular brush in the side to side direction, the ball bearings will come intact and it won't make any sound. So அந்த கிட்டுக்கு நம்ம வந்து என்ன டீச் பண்ணலாம்னா, if sound is coming from your brush, then you are brushing in the right direction. Sound வரலனா, then you are brushing in the wrong direction. So this invention is also solving the problem of teaching the kids how to brush their teeth. So in the particular left side இருக்க invention வந்து it is using multiple hardware components, software use பண்ணி ஒரு கிட்டுக்கு வந்து brush பண்றதுக்கான ஒரு guidance system யூஸ் பண்றாங்க. But the same invention on the right side, they just made a tiny modification to a already existing brush. So be it a complex mode of approach, அதாவது on the left side இருக்க invention, or be it a simple mode of approach, that is on the right side invention, both these inventions are patentable. ரெண்டுமே வந்து it is offering a same technical solution and it is addressing the same problem. ஒரே ப்ராப்ளம் தான் அட்ரஸ் பண்ணுது. டெக்னிக்கல் சொல்யூஷன் வந்து it is also teaching the kids how to brush their teeth தான் வந்து solution. And the mode of approach, one is a complex mode of approach and the other one is a simple mode of approach. So both these modes are patentable. So this particular invention is by a 6-year-old inventor. So this inventor, she applied for a patent application. அவங்களோட patent application வந்து grant ஆயிடுச்சு, and she even received multiple awards from our prime minister, and our prime minister also tweeted about this in Twitter a few months back. So why am I showing this example? In the example எதுக்கு மெயினா அங்க காமிக்கிறேன்னா, because the age of the inventor is 6 years. And why I'm stressing on the age 6 years is because there is no age limit to apply for a patent application, be it a 5-year-old or be it a 50-year-old. Anyone is open to apply for a patent application, and you don't have to hold a particular degree to apply for a patent application also. All you need to do is find technical solutions for the problems which are existing in and around you. And if you find those technical solutions to be novel and inventive, then you can apply for a patent application and the patent will be granted in your name. So start inventing and start innovating and then apply for a patent application. So that's it about patents. The next intellectual property which we are going to deal with is design. So what is design? Design, it is very simple. ஒரு ஆர்டிக்கல் இல்லை ஒரு ப்ராடக்ட் இருக்குன்னா இஃப் தட் பர்டிகுலர் ஆர்டிக்கல் ஆர் ப்ராடக்ட் இஸ் ஹேவிங் அ டிஃப்ரெண்ட் ஷேப், டிஃப்ரெண்ட் கான்ஃபிகரேஷன், டிஃப்ரெண்ட் பேட்டர்ன், அந்த பேட்டர்ன் வந்து 2 டைமென்ஷனல் பேட்டர்னாக இருக்கலாம் இல்லை 3 டைமென்ஷனல் பேட்டர்னாக இருக்கலாம். அண்ட் இஃப் தட் பர்டிகுலர் ஆர்டிக்கல் ஆர் ப்ராடக்ட் இஸ் ஏஸ்தட்டிக்லி ப்ளீசிங் டு த ஐ, ஒரு ப்ராடக்ட் நம்ம பார்க்குறோன்னா அது நல்லா இருக்கா இல்லையான்னு வந்து அவர் ஐஸ் ஜட்ஜ் இட், நம்ம ஐஸை வச்சு தான் வந்து ஒரு ப்ராடக்டை ஜட்ஜ் பண்ணுறோம். ஸோ இஃப் தட் ஆர்டிக்கல் ஆர் ப்ராடக்ட் இஸ் ஏஸ்தட்டிக்லி ப்ளீசிங் டு த ஐ ஃபார் த நான் ஃபங்க்ஷனல் ஃபீச்சர். ஸோ பேட்டன்ட்டுக்கு வந்து ஃபங்க்ஷனல் ஃபீச்சர்ஸ்லாம் பார்ப்போம், இட் ஷுட் பி டெக்னிக்கலி சவுண்ட். பட் டிசைன் ரெஜிஸ்ட்ரேஷனில் அந்த ஆர்டிக்கல் இல்லை ப்ராடக்ட் வந்து it doesn't matter if that article or product is functioning or not, because design is just purely based on the outer perspective of the product, and the top view, side view, and the outer skeletal view base பண்ணி தான் வந்து அந்த டிசைன் வந்து ஒரிஜினலா இல்லையா யூனிக்கா இருக்கா இல்லையா அப்படின்னு வந்து ஜட்ஜ் பண்ணுவோம். ஸோ பேஸ்ட் ஆன் த ஜட்ஜ்மெண்ட் we are giving a design registration to unique article or unique product. So I've given the examples of 3 products which are registered under designs. So first product, it is a chair. So what is the function of a chair? Is to sit. So what is the difference between the chair which is mentioned in this presentation and the chair which we are seeing every day and which we sit around in every day? So in the particular chair, it has a totally unique shape to it. It has totally unique color combination to it, and the size is also very unique. Since everything is unique about this particular chair, the design registration is offered to this particular product. And the second picture is an ornament. So ornament, there is anklet, bracelet, necklace, and a lot of jewelry items are there. So over ornaments, there are different patterns, different bead placement. So on the mari different patterns and bead placements for ornaments can also be registered under design. And the third picture is a cooker. So can you guys tell me what is the difference between this particular cooker and the cooker which we use in our household? வீட்டில் யூஸ் பண்ணுற குக்கருக்கும் இந்த குக்கருக்கும் என்ன டிஃப்ரெண்ட்? What is so unique about this cooker that they have given a design registration to this particular product? Can anyone answer? So for this particular cooker, they have kept the handle on the top of the lid. So usually the cooker which we use in our household, they usually keep the handle on the side of the lid. But in the cooker, they have kept the handle on the top of the lid. So as I've already told you before, design is given to non-functional feature. So it doesn't matter whether this particular cooker is functioning or not. You can still register it under design, because only the outer perspective of the cooker is viewed for this particular product. So since it has a very much unique design compared to the already existing cooker, a design registration is offered to this particular product. And even custom made clothes by fashion designers. So fashion designers, they make different embroidered clothes and leather jacket with different patterns, color patterns to it. So அந்த மாதிரி custom made clothes கூட நீங்க டிசைன்ல வந்து ரெஜிஸ்டர் பண்ணிக்கலாம். And different shapes of bottle. So every day we are using water bottles to drink water. So ஒரு water bottle, it has different shape to it, different color to it, different sizes to it. So why are these brands making these unique products? So that you can easily identify which brand does that particular bottle belong to. So suppose இப்போ ஒரு Tupperware plastic water bottle எடுத்துட்டா we can easily find out just by looking at the shape or color. So it will have a pastel color look to it, and the material will be thick, and it will have long stripes in the Tupperware plastic water bottles. So based on these identifications, we can find out which brand does the bottle belong to. ஸோ ஒரு பிராண்டும் அவங்க ஐடென்டிட்டியை வந்து ரிவீல் பண்ணுறதுக்காக ரெஜிஸ்டர் பண்ணுறதுக்காக தே டிசைன் தோஸ் ப்ராடக்ட்ஸ் இன் அ வெரி யூனிக் வே. And you might have seen these Marvel movies and Captain America superheroes and all. So he'll be holding this Captain America shield. So this particular shield is also protected under design. So can you guys tell me which brand does this bottle belong to?
One is glass cleaner.
Yep, the brand name.
Brand name is one is Harpic and one more is Collins.
Yes, exactly. So how do you say it's Harpic?
Harpic.
Design and color.
Yes, exactly. The brand name is not mentioned over here, but still you could find out which brand does the bottle belong to just by looking at the shape of the bottle and the color combination. It has a red color cap and a blue color body. So that is the power of protecting your product under design. You can create a brand identity for the particular product itself, even though there is no brand name mentioned in this particular product. So same applies for Colin also. There is just by looking at the shape and color combination, you can find out which brand it belongs to. So that's it about design. So can you guys tell me what is wrong in these pictures?
Everything is a duplicate one.
Spelling.
Sorry?
Spelling.
That
Colgate
spelling,
spelling.
everything
Yes,
is
exactly.
Spelling
Spelling
is
is
wrong.
wrong. So instead of Colgate, they mentioned Colgate. Instead of Bisleri, they mentioned Bisberry. Instead of Puma, they mentioned Puma. So why are they using misspelled names over here? Can you guys guess? எதனால இந்த மாதிரி misspelled names யூஸ் பண்றாங்க?
because people believes that is the original product.
Yes,
Original
exactly.
product நினைச்சு வாங்கலாம்.
Yes, exactly. So they are trying to use these misspelled names so that people might fail to recognize the originally trademarked brand names. So these brand names, they are trying to imitate the originally trademark brand names. So the next intellectual property which we're going to deal with is trademark. So what is a trademark? Trademark is the sign capable of distinguishing goods or services of one enterprise from another enterprise. So a company or an enterprise, what they are dealing with, whether they are dealing with goods or whether they are dealing with services. So to differentiate based on this goods or services, a sign is offered to this particular company. That sign is called trademark. So I mentioned different brand names over here: Nike, Adidas, Puma, and all. So what do Nike, Adidas, Puma sell? அவங்க நைக்கி அடிடாஸ் பூமா என்ன என்ன வந்து செல் பண்றாங்க?
Sports goods, sir.
Yes, sports goods, exactly. Very good. So they sell sports related goods. So goods mark is offered to these brands. And McDonald's, Domino's, Pizza Hut, they do restaurant services. So a service mark is offered to these brands. And Amazon is a e-commerce service. Blue Dart is a courier service, and BBC is a news broadcasting service. So again, a service mark is offered to these particular brands. So what can you protect under trademark? What can be the subject matter of trademark? So a brand name can be protected under trademark. So what are brand names? Nike, LG, L'Oreal, Coca-Cola, இது எல்லாமே brand name. நீங்க வந்து இந்த brand namesலாம் வந்து trademarkல protect பண்ணலாம். And taglines or slogans. So Nike ஓட tagline just do it, and McDonald's ஓட tagline I'm loving it. So all these taglines and slogans can also be protected under trademark, and logos or combination of colors. So Nike has the tick as a logo. So for Coca-Cola, the bottle is the logo for them. And for McDonald's, it has a color combination of red and yellow. So all these logos and combination of colors can also be protected under trademarks. So apart from these word marks, there is also a thing called sound mark. So during our childhood days, we might have watched Tom and Jerry or a lot of Hollywood movies. And the movie start ஆகிறதுக்கு முன்னாடி there will be this MGM Studios Lion Roar. So on the particular Lion Roar is protected under trademark, under sound mark. And even if you open a Netflix movie or Netflix app open பண்ணாலே there will be this Netflix intro sound. So on the intro sound is also protected under sound mark. So how to indicate your trademark? So some brands you might have seen, they might have mentioned TM on the top right corner of their brand name. சில brands வந்து R sign mention பண்ணிருப்பாங்க. Can you guess what might be the difference between TM and R? Any idea or any guesses?
Registered. R means registered.
Yes, exactly. R means registered. So நீங்க ஒரு trademark application வந்து if you have filed with the Indian in the trademark office, then you can start using the sign TM on the top right corner of your brand name. And if your particular mark has been approved by the government of India, then you can start using the sign R on the top right corner of your brand name. So can you guys some of the hidden brand names which are mentioned in these crossword puzzles? Could you guys able to find out இதான் தெரியுதா brand names, famous trademarks?
Dettol in the last row. Dettol,
Dettol, yes. What else?
Pepsi in the first line.
Yes, Pepsi. So these are the brand names: Amul, Tata, Horlicks, Bata, Link, Cadbury, Dettol. So why are we saying these brand names are famous? These brand names are famous because they have protected these brand names under trademark. The trademark கீழ protect பண்ணதுனால their brand value is retained. Brand value retain பண்ணதுனால no other company could use the same name because they have protected these brand names. Since their brand value is retained, these companies are known globally till now. So that is the power of protecting your brand names under trademark. So the next intellectual property which we're going to deal with is copyright. So what is a copyright? Copyright is an exclusive legal right granted to creators on expression of an idea. So ஒரு ஐடியாவை எக்ஸ்பிரஸ் பண்றதுக்காக அந்த கிரியேட்டருக்கு ஒரு லீகல் ரைட் கிராண்ட் பண்றோம், தட் இஸ் காப்பிரைட். So the idea is not limited to something. The idea, the expression of an idea, it can be a artistic idea also, or it can be a literary idea also. So artistic ideas na, it can be paintings or songs or films or music choreography. So adu ellame வந்து artistic ideas. Then what are literary ideas? Literary ideas can be books, illana or a novel, or else a business method, a business model, or a mathematical expression, or a computer algorithm. So all these literary works can also be protected under copyright. So copyright owner has the rights to reproduce, translate, perform. Since he is the owner, he can do anything. He can even sell his copyright to someone. He can even give permission to translate or use their work somewhere else. Copyright வந்து it is not mandatory to register your copyright, because since you are creating that particular intellectual work, you'll automatically be the owner. But it is always recommended to register, because I've already told you in the first slide that it is always better to register your intellectual work so that you will have a evidentiary value in court. Register பண்ணாதான் உங்ககிட்ட வந்து ஒரு evidence இருக்கும். So it is always recommended that you register your copyright. Not only copyright, be it any intellectual property. நீங்க register பண்ணாதான் you will have a evidence that you are the sole owner of that particular copyrighted work or intellectual work. So what are the works which can be protected under copyright? It is literary works, paintings. Literary works now already told you, the books, novels, and business models. So all those are literary works. Paintings, photography. If you click in new photograph, you can register it under copyright. Or drawings, films, music, dance, choreography, and even stone sculptures. இந்த stone sculptures பண்றாங்களா அதுவும் கூட நீங்க காப்பிரைட்ல ப்ரொடெக்ட் பண்ணிக்கலாம். So the next intellectual property which we are going to deal with is SICLDR, that is Semiconductor Integrated Circuits Layout and Design Registry. So what is a semiconductor integrated circuit? So a semiconductor integrated circuit is a complex series of transducers, dielectrics and metals. இது எல்லாமே ஒரு integrated circuitல place பண்ணி ஒரு electronic circuitry function perform பண்றதுக்காக we design a integrated circuit. So அந்த component placement, இந்த integrated circuitல அந்த component placement வந்து if it is original, if it is distinctive, அப்புறம் அந்த லேஅவுட், அந்த காம்போனன்ட் பிளேஸ்மெண்ட்டோட லேஅவுட் டிசைன் வந்து ஒரிஜினலா இருந்ததுன்னா you can protect that integrated circuit under SICLD Act 2000 and SICLD Rules 2001. So very interesting example or famous example for integrated circuit protected product is MacBook, Apple oda MacBook Pro. So if you take a normal laptop, there will be a separate chip for a processor, separate chip for a storage. But Apple, they've released it with a chip called M1 chip. And the MacBook Pro M1 chip irukku. So on the M1 chip they have integrated both the processor and storage in a single chip called M1 chip. So on the M1 chip is protected under SICLD design. So the next intellectual property which we're going to deal with is GI, that is geographical indication. So what is a GI? A GI is a sign used on a product that have specific geographical origin and possesses quality or reputation that are due to that origin. So basically ஒரு ப்ராடக்ட் வந்து அந்த சிட்டி இல்லை அந்த டிஸ்ட்ரிக்ட்னால ஃபேமஸாக இருந்ததுன்னா அந்த ப்ராடக்டை வந்து நீங்கள் ஜிஐக்கு ரெஜிஸ்டர் பண்ணலாம். தென் அ ஜிஐ சைன் வில் பி given to your particular product. So examples of GI registered products in India are mentioned over here. Kanyakumari clove, Tirupati laddu, Kanjipuram silk, Mysore sandal soap. So the Kanjipuram silk, what is so unique about this Kanjipuram silk sarees? So the sarees which are woven in Kanjipuram, those sarees, that particular silk has a quality to it. And the silk is grown and it is developed in the city district of Kanjipuram. So the Weavers Association of Kanjipuram, they approached GI office and they have registered this Kanjipuram silk for GI protection. So in the mari ஒரு சிட்டிலையும் ஒரு ஸ்டேட்லையும் if a particular product is famous and if it has a geographical connect to that particular city or district, so on the product வந்து நீங்க GI கீழ protect பண்ணிக்கலாம். So now can you guys give me some examples where product is famous because of a particular city or a district? ஒரு ஏரியாவால ஒரு ப்ராடக்ட் ஃபேமஸா இருக்கு அப்படின்னு can you guys give me some example? Like
எங்க ஊர்ல கடலை மிட்டாய்.
திருநெல்வேலி அல்வா. எஸ், கடலை மிட்டாய் எந்த ஊர் சார்?
கோவில்பட்டி
எஸ், கோவில்பட்டி கடலை மிட்டாய். எஸ், that is a GI registered product. Sorry?
பட்டமட பாய்.
Yes, பட்டமட பாய் is already mentioned.
காரைக்குடியில அந்த சுங்க சாரின்னு சொல்லுவாங்கல்ல சார், கடம்பூட்டா சாரி.
அப்புறம் தஞ்சாவூர் டால், தஞ்சாவூர் பெயிண்டிங்ஸ் and Mahabalipuram stone sculptures.
மதுரை மல்லி.
Yes, Madurai Malli. And these are the further examples. Dindikkal lock. Yes, Darjeeling tea, Kodaikanal Malaipoondu. Kodaikanal Malaipoondu is a recently registered GI product. And Kovilpatti Kadala Mittai, as you guys told already. So these are the various examples of GI registered product. Okay. So in a single product, ஒரு single product லயே multiple intellectual properties can be used and protected in a single product. To explain that, I have taken the example of a MacBook Pro. So இந்த MacBook Pro எடுத்துக்கிட்டிங்கன்னா the LED display of a MacBook, அந்த display வந்து it is protected under patent. The body of the laptop, so அந்த MacBook ஓட body பாத்தீங்கன்னா it has a very unique color to it, unique shape to it. So that body of the laptop is protected under design registration. And the very famous Apple logo, and the Apple logo is protected under trademark. And the user manual which they give with the MacBook Pro, it is protected under copyright. And the layout of integrated chip, as I've already told you, on the integrated chip only, it is protected under SICLD design. So now I've explained you what are the different types of intellectual property. One definition I've told you. What are the works which can be protected under each and every intellectual property? I've explained you that also. So I need you guys to answer எந்தெந்த ஆர்டிக்கல் வந்து எந்தெந்த intellectual property-ல protect பண்ணணும். So first picture is a painting of a Mona Lisa. Under which IP you can protect it?
Design.
No, painting is an expression of an idea.
Copyright.
Yes, exactly. Copyright is the right answer. And what about the second article? There are multiple products. Multiple IPs can also be used here. Second picture, எந்த IP-ல protect பண்ணணும்?
Trademark.
Yes, logos can be protected under trademark. What else? You can use design also, because ஒரு product it has unique design to it. Okay. And what about the third article? Stone sculpture. It can be protected under which IP?
Geographical இதா sir?
The stone sculpture is also protected under copyright only. And what about the fourth article? Distillery name, brand name?
Trademark.
Yes, exactly. Trademark is the right answer. And what about the fifth article?
This is also trademark.
Yes, trademark. And then you can know the shape of the bottle. அது எதுல protect பண்ணணும்?
Design.
Yes, exactly. Design also. Very good. And what about the sixth one?
SIGL.
Yes, SICLD. You can use it using semiconductor integrated circuit layout and design registry. Very good. Okay, let's move on to the next slide now. So now we'll look at the validity for each and every intellectual property. So patent, I've already told you the validity is 20 years. And one more point which you need to remember is there's nothing called global or international patent. As I've already told you, and the last line you mentioned, Manirka, all IP rights are territorial in nature. எந்த கண்ட்ரியில் நீங்கள் வந்து ஐபி ரைட் ப்ரொடெக்ஷன் அப்ளை பண்ணுறீங்களோ அந்த கண்ட்ரியில் மட்டும்தான் உங்கள் ப்ரொடெக்ஷன் வந்து வேலிடாக இருக்கும். அண்ட் ஃபார் டிசைன் ரெஜிஸ்ட்ரேஷன் த வேலிடிட்டி இஸ் 10 years ப்ளஸ் யூ கேன் renew it for another 5 years also. And for trademark the validity is indefinite, and for GI the validity is indefinite, and for copyright it is the lifetime of the author plus 60 years. So ஒரு author வந்து ஒரு நாவல் எழுதுறாரு, this is for literary works. Copyright ஓட literary works ஓட validity வந்து lifetime of the author plus 60 years. So அந்த author ஓட whole lifetime plus from the day of his death, அந்த டேல இருந்து 60 years is the validity for copyright in case of literary works. So artistic works like paintings or photograph, the day it was published or the day it was shown to the public, on the date landu 60 years is the validity. And for SICLD the validity is 10 years. So who can apply for a intellectual property? யாரெல்லாம் apply பண்ணலாம்? Either a person or a legal representative. A person means it can be used students or faculties, it can be a educational institute, it can be a small entity, or startup, or body corporate. All those person can apply for a intellectual property or அவங்களோட legal representative. ஆனா GI-க்கு an individual cannot apply for a GI protection. Either an association which is related to the geographical area or a society which is related to the geographical area. Either association or society, அவங்க மட்டும்தான் GI protection apply பண்ண முடியும். An individual cannot apply for a GI protection. So if you are applying for a patent protection, patent application with the Indian Patent Office, then for a natural person இல்ல ஒரு ஸ்டார்ட்அப் இல்ல ஒரு எஜுகேஷனல் இன்ஸ்டிடியூட்டுக்கு the basic filing fee will be 1600 and examination fee will be 4000. So totally fee of 5600 has to be paid. So நீங்க ஒரு கார்ப்பரேட் இல்ல ஒரு கம்பெனியா இருந்தீங்கன்னா then the basic filing fee will be 8000 and examination fee will be 20000. So totally you need to pay a fee of 28000. So filing procedure அப்படின்னா either you can come directly to the office and you can submit your patent application offline in office itself, or if you're living very far away from the office, there is an online filing portal. So in the filing portal மூலமா you can upload your patent application as soft copies upload பண்ணி you can apply for a patent application through this online filing portal also, e-filing portal. So these are the very important points to remember before you apply for a intellectual property protection. First point என்னன்னா, first protect and then publish. So what do you mean by protect and then publish? Suppose if you guys are doing research work, இல்ல PhD, இல்ல final year students இருந்தீங்கன்னா, you'll be working on a research work or research project you'll be working on it. So on the project you'll be very much keen on ஒரு ஜேர்னல்ல பப்ளிஷ் பண்ணணும் இல்லைன்னா கான்ஃபரன்ஸ்ல ப்ரெசென்ட் பண்ணணும்னு you'll be very much eager towards it. ஸோ ஒன்ஸ் உங்க ரிசர்ச் ஒர்க் இல்லை உங்க ஐடியா ஜேர்னல்ல பப்ளிஷ் பண்ணிட்டீங்க இல்லை கான்ஃபரன்ஸில் ப்ரெசென்ட் பண்ணிட்டீங்கன்னா இட் வில் பி ஆல்ரெடி இன் த பப்ளிக் டேட்டா பேஸ். ஸோ பப்ளிக் டேட்டா பேஸ்க்கு வந்துடும். ஸோ இன் லேட்டர் பாயிண்ட் ஆஃப் டைம் இஃப் யூ வாண்ட் டு அப்ளை பேட்டன்ட் ப்ரொடெக்ஷன் ஃபார் தட் பர்டிகுலர் ரிசர்ச் ஒர்க் ஆர் ஐடியா, your own published document will be used as a prior art to kill the novelty of your work. So unga publish ஆன டாக்குமெண்ட்டை வச்சே நாவல்ட்டி கில் பண்ணிடுவாங்க அந்த பேட்டன்ட் அப்ளிகேஷனுக்கு. So it is very much important that you first get your patent protection and then go for publication. So what is the second point? Rights are territorial. It is limited to the boundary of a country. I've told you multiple times that all intellectual properties are territorial in nature. The third point is registration is done by sovereign authority. That is, Government of India gives you the registration certificate. Fourth point, no automatic relief. You need to file for an infringement suit. So suppose actually Government of India would role it gets over once they provide you with the registration certificate. So after that you need to take care of that intellectual work. Suppose ஒரு யூடியூப் வீடியோ எடுக்கிறீங்க இல்லை ஒரு நாவல் காப்பிரைட்டட் நாவல் வச்சிருக்கீங்கன்னா, if someone is copying your work அது உங்களுக்கு தெரிய வந்ததுன்னா you have the right to file a infringement suit against them in the court. உங்க பெர்மிஷன் இல்லாம உங்க ஒர்க்கை காப்பி பண்றாங்க இல்லை பெர்மிஷன் இல்லாம யூஸ் பண்றாங்கன்னா you have the right to file an infringement suit against them in the court. But you need to constantly monitor and keep a track on your intellectual work. So that is your sole responsibility to constantly monitor your intellectual work so that you get your work protected and covered. And the fifth point is renewal fees to be paid for some intellectual properties. Once your intellectual property is approved by the Government of India, you need to pay renewal fees every year except for the copyright. So let's quickly summarize what we have dealt till now. What is a patent? Patent is given to an invention or innovation. The validity is 20 years. What is design? Design is given to an article or product based on the non-functional feature and it is solely judged by the eye based on the aesthetics. Adoda duration 10 years plus 5 years. Trademark is a sign which is given to a company to distinguish between goods or services. Validity is indefinite. You need to renew it for every 10 years. And what is copyright? A copyright is a legal right granted to creators for expression of an idea. Although validity 60 years. What is a GI? A GI is a sign which is given to a product based on the geographical origin. So for that also validity is indefinite. And what is SICLD? It is a layout of transistors and other circuitry elements to perform an electronic circuitry function. So other validity 10 years. So where to approach for protection? So if you want to apply for a patent protection, then there are 4 offices in India, that is in Kolkata, Delhi, Chennai and Mumbai. If you want to apply for a design registration, there is an office in Kolkata. For trademark registry, already mentioned 4 offices, plus there is an additional office in Ahmedabad. And for GA registry, there is an office in Chennai. And for copyright and SICLD registry, there is an office. There are 2 different offices in Delhi. So this is the official website for intellectual property office, Government of India. So the link is URL is ipindia.gov.in. ஸோ நீங்கள் வந்து ஒரு பேட்டன்ட் அப்ளிகேஷன் இல்லை டிசைன் அப்ளிகேஷன் இல்லை ட்ரேட்மார்க் அப்ளிகேஷன் எந்த அப்ளிகேஷன் ஃபைல் பண்ணனாலும் யூ நீட் டு விசிட் திஸ் பர்டிகுலர் சைட் and you have to access this site to apply for your intellectual property protection. So if you could see, there is comprehensive e-filing. So in the e-filing, once you click that, you will be redirected to online e-filing portal. So in the portal மூலியமா தான் வந்து நீங்க வந்து பேட்டன்ட் அப்ளிகேஷனை வந்து அப்ளை பண்ணணும். So further, if you want to search for patent applications which are applied in India, இங்க public search ன்ற ஒரு option இருக்கு. You can go through that. And there is patent acts and rules and patent manuals and guidelines. So to enhance your knowledge in patent application, you can refer these documents. And there is a separate link for copyright office and SICLD office. So if you click this particular link, then you can then you will be redirected to this particular website. So what can we do with IPR? IPR, what are the career prospects in intellectual property rights? So if you enhance your knowledge in intellectual property rights, and if you are a science graduate or an engineering graduate or a technology graduate, you can become a patent agent. You can become a registered patent agent with the Government of India. And if you are good at content writing and if you have good technical knowledge, you can become a patent drafting specialist. And you can also become a patent analyst. So உங்ககிட்ட ஒரு ஐடியா இருக்கு, ஒரு ரிசர்ச் ஒர்க் இருக்கு, but you are not sure whether it will get granted or not. So if you approach a patent analyst with this particular idea, he will give a initial opinion whether your idea will be granted or refused. If you are a law graduate, you can either work in trademark or copyright firms, and you can also work in IPR policy making and IPR cells in various research institute or educational institute also. And you can also join government intellectual property rights office as a trademark examiner or an examiner of patents and designs like me also. So these are the various career prospects if you enhance your knowledge in intellectual property rights. So that's it with the end of the presentation. We'll have a small quiz and then we'll move on to the query session. So which type of IP protects the painting painted by artist?
Copyright.
Yes, exactly. Copyright is the right answer. So the next question, what protects the intellectual property created by fashion designers?
Registered designs.
Yes, exactly. Registered design is the right answer. So next question, what protects the advanced disc brake for bike developed by the inventors?
Patents.
Yes, again, pattern is the right answer for this question. Which of these is a geographical indication?
Pasani saree.
Yes, Paithani saree is the right answer. So geographical indication nale there will be always a city name or district name வந்து product name க்கு முன்னாடி இருக்கும். So அதை வச்சு நீங்க கண்டுபிடிச்சிடலாம் easy. So next question, what does a trademark protect?
Logo, names and brands.
Yes, exactly. Logos, names and brands. What is the validity for patent?
20 years.
Yes, exactly. 20 years is the right answer. So if you write an original story, what type of intellectual property gives you the right to decide who can make and sell copies of your work?
Copyright.
Yes, copyright is the right answer. So the next question, imagine a cricketer sets up his own company to sell his own range of clothes. What type of intellectual property can he use to show that the clothes are made by his company?
Trademarks.
Yes, exactly. Trademark is the right answer. So if he wanted to protect the clothes which he is making, the design of the clothes, which intellectual property he should go for? On the clothes or the design protect பண்ணனும்னா which IP he should go for?
Patent.
No. Registered.
Copyright.
No.
Registered designs.
Yes, registered design is the where fashion designers protect their custom made clothes. So the next question, if a company develops a new technology that improves its main product, what type of IP can they use to stop others from copying their invention? Invention, innovation, all these will come under.
Copyright.
Yes,
Patent.
patent is the right answer.
Patent.
Yes, exactly. Patents is the invention, innovation, all these things will always come under patent only. Okay, that's it at the end of the questions. So you'll be receiving a e-certificate from the Government of India. This is a sample certificate. So kindly provide your mail ID and name to the coordinator so that you'll be receiving these certificates to your mail ID. So that's it with the end of the presentation. If you have any questions or queries, you can ask me. Any doubts regarding any intellectual property?
சார் ஒரு டவுட் இருக்கு சார்.
சொல்லுங்க சார்.
நம்ம பேட்டன் ஃபைல் பண்றோம் அப்படின்னா அது வந்து நம்ம இந்தியால ஃபைல் பண்ணோம் அப்படின்னா இந்தியால மட்டும் தானே கவர் ஆகும்.
ஆமா சார்.
அப்போ நம்ம வந்து ஃபைல் பண்ண உடனே நீங்க பப்ளிஷ் பண்ணிடுறீங்க, அது ஆன்லைன்ல வந்துருது இல்ல சார். அப்போ எல்லாருமே அதை வந்து விசிட் பண்ணுவாங்கல்ல, எல்லாருமே பார்ப்பாங்க. அப்போ அது
கண்டிப்பா சார்.
யாரும்
எது சார் யார் வேணா
யாரெல்லாம் அதை யூஸ் பண்ணலாம்ல சார். ஃபாரின் அமெரிக்கால இருக்கிற ஒருத்தர் வந்து நம்மளோட பேட்டன் வந்து பார்க்கறாங்க அப்படின்னா அவங்க அதை டிசைன் பண்ண தானே செய்வாங்க.
ஆமா சார், யூஸ் பண்ணுவாங்க தான் சார்.
அப்போ நமக்கு எப்படி பெனிஃபிட் இருக்கும்
சார்? நீங்க வந்து இப்ப இந்தியால அப்ளை பண்றீங்கன்னா இந்தியால மட்டும்தான் உங்களுக்கு ப்ரொடெக்ஷன். ஸோ இந்தியால மட்டும்தான் நீங்க வந்து மார்க்கெட் வேல்யூ நல்லா இருக்கு. நீங்க வந்து ஒரு பேட்டன்ட் ப்ரொடெக்ட் பண்றீங்கன்னா அந்த ப்ரொடெக்ஷன் வந்து உங்க ஐடியாவுக்கும் தான் சரி, அதை வச்சு ஃபியூச்சர்ல வந்து எப்படி கமர்ஷியலா யூஸ் பண்ண போறீங்க, மார்க்கெட்ல எப்படி செல் பண்ண போறீங்க அப்படின்றத அனலைஸ் பண்ணிட்டு தான் ஒரு கண்ட்ரியில வந்து ஒரு பேட்டன்ட் அப்ளிகேஷன் அப்ளை பண்ணுவீங்க. ஸோ பேட்டன்ட் அப்ளிகேஷன் அப்ளை பண்ணிட்ட பிறகு நீங்க கண்ட்ரி இந்தியாவில் தான் உங்களுக்கு வந்து மார்க்கெட் பொட்டென்ஷியல் நல்லா இருக்குன்னு தெரிஞ்சு நீங்க இந்தியாவில் மட்டும்தான் ப்ரொடெக்ஷன் வாங்கியிருக்கீங்க. சப்போஸ் வேற ஒரு கண்ட்ரிலையும் உங்களுக்கு வந்து மார்க்கெட் வேல்யூ நல்லா இருக்கு, இந்த ப்ராடக்ட் அங்கே நல்லா செல் ஆகும் அப்படின்னு ஃபீல் பண்ணீங்கன்னா நீங்க அந்த கண்ட்ரிலையும் வந்து உங்க ப்ரொடெக்ஷன் வந்து பேட்டன்ட் ப்ரொடெக்ஷன் அங்கேயும் வாங்கி வச்சுக்கலாம். ஸோ இட் டசன்ட் மேட்டர் அவங்க உங்களோட ப்ராடக்ட் வந்து ஆல்ரெடி ஃபாரின் கண்ட்ரியில் யூஸ் பண்ண ஆரம்பிச்சிட்டாங்கன்னா கூட நீங்க ஆல்ரெடி இனிஷியலா அவங்களுக்கு முன்னாடி இந்தியால வந்து ஃபைல் பண்ணி பேட்டன்ட் ப்ரொடெக்ஷன் வாங்கி வச்சிருக்கீங்க. ஸோ பேஸ்ட் ஆன் தட் ஃபேக்ட் யூ கேன் கெட் ப்ரொடெக்ஷன் இன் அதர் கண்ட்ரி ஆல்சோ. இதை வந்து ப்ரையாரிட்டியா யூஸ் பண்ணி நீங்க வந்து மற்ற கண்ட்ரிலயும் வந்து ப்ரொடெக்ஷன் வாங்கிக்கலாம். மற்றவங்க யாராவது யூஸ் பண்ணியிருந்தாங்கன்னா கூட அவங்கள நீங்க சூ பண்ணலாம். யூ ஹாவ் த ரைட் டு டூ இட். Any other questions?
Sir, I have one question.
Yes, sir.
Sir, what are the charges for filing a patent or a copyright?
Patent, I've already told you, if you are an individual, இல்லை ஒரு காலேஜ் மூலிமா ஃபைல் பண்ணுறீங்கனாலோ அது பேசிக் ஃபைலிங் ஃபீ வந்து 1600 வரும். ஸோ அண்ட் examination fee will be 4,000. So totally you need to pay a fee of 5,600, sir. So copyright வந்து I think you need to pay around 4,000 or 5,000. I'm not sure about it because I don't work under copyright, but you can visit the copyright website. You can get a clear idea on the fees. I think it's approximately around 4,000.
Sir, I have one more doubt.
Yes, sir.
If two persons are filing for a patent at the same time, both will be given the for same work. How you are giving the patent?
இந்த டவுட் வந்து எல்லாருமே கேட்குறாங்க. பட் till this date no application has been filed like that. ஒரே இன்வென்ஷன் ஒரே கிளைம்ஸ் எல்லாமே டிட்டோவா யாருமே இது வரைக்கும் ஃபைல் பண்ணதே இல்லை அட் த சேம் டைம். ஈவன் இஃப் இட் ஹேப்பன்ஸ் அந்த டைம் டிஃபரன்ஸ் பேஸ் பண்ணி தான் நம்ம ப்ரையாரிட்டி சூஸ் பண்ண முடியும். ஃபர்ஸ்ட் கம் ஃபர்ஸ்ட் சர்வ் பேசிஸ் தான் சார். ஹூ ஃபைல்ஸ் ஃபர்ஸ்ட் அந்த இன்வென்ஷனுக்கு தான் வந்து வில் பி கிவன் ப்ரையாரிட்டி. அந்த லேட்டர் ஃபைல்டு பர்சன் won't be getting the priority.
இல்லை அதாவது few minutes, few hours or few weeks இந்த மாதிரி difference ஒரே ஒர்க்ல இருக்கிறாங்க
This is
இல்லையா?
a hypothetical question. This has never happened before. This has never happened till now, sir.
இல்லை எனக்கு என்ன டவுட்னா இப்போ ஒருத்தர் போய் பேட்டன்ட் இன்வெஸ்டிகேட்டரையோ யாரையோ அப்ரோச் பண்ணிட்டு இருக்காங்க எப்படி பண்ணலாம்ட்டு, இன்னொருத்தர் ஃபைல் பண்ணிடுறாரு, பட் சேம் ஒர்க்குன்னு வச்சுக்கோங்களேன்.
பட் யார் வந்து ஃபர்ஸ்ட் ஃபைல் பண்றாங்களோ they'll be given priority, sir. அவங்களுக்கு தான் வந்து they'll be given first priority. அப்புறம் செகண்டா ஃபைல் பண்றவங்க it will be loss for them only. So that's why I'm saying that even you don't go for publication of your research work, first get a patent protection and then go for publication of your research work in any journal or conference, be it whatever it is. Because priority once lose ஆயிடுச்சுன்னா you cannot gain it back in patent applications.
Thank you, sir. Thank you.
Okay.
Excuse me, sir.
Yes, sir.
Sir, could you please tell about the Kabila scheme for innovators?
So Kapila scheme வந்து actually it is not under our jurisdiction. I think AICT தான் வந்து அந்த ஸ்கீம் ஸ்டார்ட் பண்ணாங்கன்னு நினைக்கிறேன். I think
it's not applicable for arts and science colleges.
I think it's applicable only for engineering colleges, I think so, sir. But I'm not sure about that scheme because it is not coming under our jurisdiction. அது வந்து as far as I know, I think they are giving a patent application fees of around 5,000 for one patent application, and you need to satisfy some criteria that you need to form a committee where there are 4 persons and one intellectual property expert should also be there in the committee. There are certain rules which you need to adhere before you apply for the Kapila scheme, sir.
Okay, sir. Because our college has registered under Kabila scheme, that's why I'm asking.
Okay. It's not under our jurisdiction, sir. So you can visit the site and check out.
Okay, sir. Thank you.
Okay.
Sir, I have one more question, sir.
Yes, sir.
Actually, during 2015, I have filed one patent, sir, in Chennai office. 2017 it was published, sir. And 2018 we filed on examination.
Okay,
actually,
sir.
It is an under examination, sir. What is the next step, sir?
So once it goes to the examination process, examination போயிட்ட பிறகு your application will be reviewed. Reviewed in the sense we will check whether your application has been drafted in compliance with patent acts and rules. And the formal examination will happen, and the technical examination also will happen whether your application is novel or inventive. And the technical search on the side by side will happen, and they will prepare a report and then they will send it to you, sir. So on the report based பண்ணி, if you are not satisfied with the report, and if you feel that the prior art or on the search வந்து உங்க ஐடியாவோட ரெலவெண்டா இல்லைன்னா, you can reply back to the office. And if you have adhered with all the rules, then a patent will be granted. அப்படி இல்லைன்னா they will call you for hearing கூப்பிட்டு they'll tell you to explain about the invention. Then once if the controller is satisfied with your reply, then a patent will be granted towards your invention, sir.
Sir, அதுதான் ஆக்சுவலி எவ்வளவு பீரியட் ஆகும் சார்? ஆக்சுவலி நியர்லி 3 to 4 years ஆக போகுதுன்னு நம்ம நினைக்கிறோம். 2018 or 19ல வந்து அண்டர் எக்ஸாமினேஷன் ஃபைல் பண்ணோம். பட் இப்போ 22 ஆயிடுச்சுல. இப்போ அந்த 4 years நியர்லி 4 years ஆக போகுது.
ஆமா சார்.
ஸ்டேட் பண்ணோம் அப்படின்னா அண்டர் எக்ஸாமினேஷன் அப்படிங்கிறது இருக்கு. அதனால என்னன்னு கேட்குறோம். எவ்வளவு நாள் ஆகும் சார்? அதுக்கு ஏதாவது அப்ராக்சிமேட் டேட் பீரியட் ஏதாவது இருக்கா?
There is no approximate date or period, sir, but there are a lot of pending work which are already in our office, but we are trying to overcome all those pending works right now. So within a few months or few years, not few years, within few months your case will be, you'll get a reply, sir.
Yes, okay.
Any other doubts? For the doubts, you can mail us to nipam-chennai@gov.in, and you can also visit the site ipindia.gov.in to get clarified about any patent acts or trademark acts or any copyright act, whatever it is. So, yes.
Sir, I have one more question.
Yes, sir.
Sir, if I got patent using this that technique or technology, I am to start industry. I am planning. For that, I have to get a license from government, no, sir?
If you are starting an industry, yes, definitely you need to get a license from the government. We need to first register your company, and then you need to get a license also, sir, based on what the industry is about. But for patent, you don't need anything as such. Only an idea is needed. If you have an idea with you, you can go and apply for a patent application.
But I have one question. If I am registering a patent with some procedures or methods, the patent examiners are not checking whether the technology works or not. Right, sir?
Yes, actually, it doesn't matter if you have a working model or not, but the idea which you are presenting. But நீங்க வந்து ஒரு patent application draft பண்றீங்கனாலே, you need to disclose everything. You need to disclose how is it going to work, what are the materials you're going to use, and what are the outcome, what is the solution. So அது எல்லாமே நீங்க வந்து you have to fully disclose in the description. So based on that only, we will search whether this idea is already published somewhere else, வேற யாரா வந்து யூஸ் பண்ணிருக்காங்களா இல்லையான்னு we'll search in databases, and if we find out that nothing else is available, then a patent will be granted towards invention. And as you asked, it doesn't have to be a working model. Working model இருந்தால் தான் வந்து patent application apply பண்ணணும்னு கிடையாது. Even if you have an idea, but that idea should be fully constructive. அது வந்து futureல you should be able to develop into a product or a process of doing something. So அது வந்து clear-ஆ இருக்கணும். But as of now, when you are applying for a patent application, you don't have to have a working model.
So it may be a theoretical idea, may be also patented.
Yes, sir. Sure.
Thank you, sir.
Do we have any further queries or questions?
No, sir.
Okay then. So thanks a lot for giving me the opportunity to share my knowledge, and thanks for being such an interactive audience also. Thanks a lot, everyone.
Thank you very much, sir. Thank you so much for your words and wisdom. Thank you, sir. Let me invite Dr. N. Shanmupriya, ma'am, Assistant Professor of Mathematics, to deliver vote of thanks.
Good evening to one and all present here. It gives me an immense pleasure to present vote of thanks in this auspicious occasion. First of all, I would like to thank God Almighty for their gracious presence through the meeting. Next, I would like to express my gratitude to Dr. P. Sandaraman, Assistant Professor, Department of Chemistry, for his welcome address. Thank you, sir. Behind every successful institution, there is an efficient administrative professional. I would like to thank our Secretary, Dr. P. Mahendran, for his presidential address. Thank you, sir. Next, I would like to thank the person who has the capacity to translate vision into reality, and her actions inspire others to dream more, learn more, do more. I would like to thank our beloved principal, Dr. N.R. Sandhi Maheswari, for her felicitation address. Thank you, ma'am. I extend my deepest gratitude to Dr. G. Chellaturai, Assistant Professor, Department of Zoology, for his chief guest introduction. Thank you, sir. Now it's time to thank Mr. M. Madan Raj, Examiner of Patent and Designs, Indian Patent Office, Chennai, for spending his valuable time with us and giving such a brief knowledge about patents. Thank you, sir. Next, I would like to thank the research committee convener and members for arranging this meeting, a useful meeting. Next, I would like to thank my dear staff members for their fullest cooperation throughout the meeting. Thank you, one and all. Thank you.
Thank you, ma'am.
Thank you,
Thank
ma'am.
you all. The attendance sheet will be posted on our GVN staff WhatsApp group.
Yes.
Sir, shall I end the session?
Yes, sir.
Okay.
Thank you so much.
Thank you, sir.
Free certificate will be provided only those who have filled the attendance sheet. Please have a look on our WhatsApp group.
Thank you,